You should be able to do that.
I just want to go to sleep. All right, this I can breathe. Because she's about to give a speech.
Let me clear my throat.
I started doing it. James took a speech class, and he was getting on my nerves. Like every time he's about to talk, I'm like, that's unnecessary. That was not. My dad gives me. So, it's some words in it. And there's like a picture of a man holding his daughter's hand in his heart. He gave me when I was 6. I thought I was gonna die. I hope I never lose it. If so, oh well.
I got it.
You're right. Brenda is like a husband.
You guys don't seem all that stressed out to me.
I am. I ain't trying to
We have no
yet.
brain left. I'm sick.
Pretty relaxed to me.
I'm not the follow this chick.
So I'm bitter that it's cold. I hate being cold, so I have to. Especially, of course, you know where I was yesterday. And I had on flip-flops and shorts. It was 81 cold. I keep telling you all. Frontier, $29 each way. I told you, I don't want to see you on my plane. But, well, if you saw what I look like outside of the building, it's embarrassing. Anywho, today we are continuing our discussion. So where have we gone? What road have we traveled? Well, this is what we know so far. We know that to file a case in civil court, we need proper service of process. We need personal jurisdiction, which are several ways to satisfy that. We need proper venue, and what was my last one? Subject matter jurisdiction. We learned last class that subject matter jurisdiction can be satisfied in 2 ways: diversity jurisdiction or federal question jurisdiction. And the statutes that were created for those 2 requirements are 1331 for federal question, 1332 for diversity jurisdiction. We also learned in the last class that federal question jurisdiction deals with, it means whatever the lawsuit is about is dealing with a federal treaty or something, a question regarding the Constitution, like a type of statute or amendment, First Amendment, Fourth Amendment, something of that nature. And what else was there? Diversity jurisdiction, the 2 requirements, diversity of citizenship, so the plaintiff and defendant have to be domiciled in different states, and the amount of controversy has to be over $75,000. We also learned the complete diversity rule, reminding you that no one on either side of the little v, so the plaintiff versus defendant. So no plaintiff or defendant can be domiciled in the same state, so there's no diversity of citizenship, and you cannot use subject matter jurisdiction to get your case filed in federal court. We learned a lot. Now imagine if I had just said all that the first day of class. We didn't need to do all this, did we? No. Sort of, right? Maybe? We did. You understand it in all the cases. All right, so where are we today? Today we are adding 2 more pieces to the puzzle, which are supplemental jurisdiction and removal. So are we ready to jump into these 2? Yes. Since some of you may not have read extensively, just a preview. Supplemental jurisdiction just says, you know what, I got my case in federal court either based on federal question jurisdiction or diversity jurisdiction, yay. But darn, I have some other claims that are state law claims. Do I have to go and try those cases in state court, or is there a way I can attach all my claims to the same federal lawsuit? And that's what supplemental jurisdiction allows you to do. It allows you to attach state law claims that normally could not get into the federal court system on their own, so that you can consolidate your cause of action into one lawsuit, which is very helpful, efficient, and less expensive. We'll talk about removal. It's, the plaintiff has filed their case in state court, but I want to remove it to federal court. So it's not like transfer, or it's an improper venue, it's just, I want it in a different court system, okay? And so we'll talk about the rules or criteria in place to have your case transferred from one court system to another, from state court to federal court. Are we ready? All right. So, supplemental jurisdiction is what we'll start with today. So in addition to diversity jurisdiction and federal question jurisdiction, federal courts have expanded their jurisdictional reach, through the doctrine of supplemental jurisdiction. So basically the doctrine of supplemental jurisdiction allows a federal court at its discretion to add claims that independently lack federal jurisdictional basis, such as state law claims. So again, the doctrine of supplemental jurisdiction allows a federal court in its discretion, to add claims that independently lack a federal jurisdictional basis. So it allows them to add claims that independently lack a federal jurisdictional basis, such as state-based claims. All right, so until 1990, the doctrine of supplemental jurisdiction was a judicially based doctrine, meaning it was based in cases. There was no statute that kind of made it, as you say, codified it into law. But in 1990, Congress said, you know what, a lot of the judges are saying this type of jurisdictional breach is acceptable. Let's go ahead and solidify this law and create a code, which is 1367 of the USC. So that is the current supplemental jurisdictional statute. And all assertions of supplemental jurisdiction are governed by this 1367. All right, so we're going to discuss the rules. The statutory rules for supplemental jurisdiction, and then we might do some hypos, or I might save them for the next class when we've had a chance to actually really read supplemental jurisdiction, and go on from there. So before we talk about the statute, I just want to stress 2 main things. I'll email it to you. It's just 1367A. If you Google it, it's just verbatim the statute. It comes right up, and I'll attach this email, or I'll just email it. It's not a big deal. Some people can't see. So basically, there are 2 main things that you need to remember about supplemental jurisdiction. The first is that supplemental jurisdiction is never available, so again, never available to get the original case in federal court. It's only available for additional claims. So again, supplemental jurisdiction is never available to get the original claim into federal court. it's only available for additional claims. So the plaintiff must assert at least one claim that either meets federal question jurisdiction or diversity jurisdiction. So it can never be used to get an original case in federal court. It's only available for additional claims, only add claims. Can't be used as a jurisdictional basis to get a case in federal court. Second, supplemental jurisdiction is not needed. So second thing to remember is that supplemental jurisdiction is not needed if there is, which makes sense, an independent basis for subject matter jurisdiction over the claim. So you don't need to use supplemental jurisdiction, obviously, if it already meets either federal question or diversity jurisdiction. So again, if the claim itself qualifies for diversity jurisdiction or federal question jurisdiction, you do not need to use supplemental jurisdiction. So the issue of supplemental jurisdiction becomes relevant when you see, or hear, the following fact pattern. So essentially what typically happens is that the plaintiff has filed a case that satisfies some basis for subject matter jurisdiction in federal court, and you can say that the claim satisfies, again, an independent basis to get into federal court. But the plaintiff may, as the lawsuit progresses, have additional claims they want to add. Because a lot of times what happens is you may file your initial claim for negligence, right? You have diversity of citizenship, the amount of controversy is over 75,000. But as you go through the litigation process, as you all learn in about 2 weeks, there's discovery. Discovery is exchange of information between the two parties that they use, exchange of evidence essentially that will be used to try the case. And sometimes in discovery, you're like, oh, I didn't realize, I thought this was just a negligence claim. It's actually a product liability claim as well, because the valve they put in my mom's heart looks like it was defective in some way, and we didn't realize that until we brought some experts in. So now I want to add the state-based claim to my original lawsuit. So that's an example. And so the defendant may want to add. Another scenario where it happens is when plaintiff files a case against defendant, and you'll learn this later on. Let's say I mentioned it earlier in the semester, they're like business partners, the defendants, and the plaintiff only files a case against me and doesn't include my business partner in the lawsuit. Well, what they're suing me for, if we are guilty, my business partner and I are going to be jointly and severally liable. So he needs to be in the lawsuit as well. I'm not going to take the fall. So I can use a tool called Impleader and basically force him to join the lawsuit, even though the plaintiff didn't add that party to the lawsuit. I can force him to come in through this civil procedure rule, right? And let's say, oh, well then the plaintiff says, well now the co-business partner's in here. I've got some claims against him as well that are state-based claims, and it would make sense in that situation to just add those claims to the lawsuit if they're all kind of centered around the same case or controversy. So it's just a way of making the litigation process more efficient by allowing claims that normally would not be allowed in federal court to be heard. Okay. All right. So the key is that every single claim asserted in federal court, not just the plaintiff's original claim, but every single claim must satisfy a basis for federal subject matter jurisdiction. And so let's talk about the statute specifically, 1367. So 1367A basically states, as you can see, that the district courts have supplemental jurisdiction over all claims and over claims that involve the joinder or intervention of additional parties that are so related to the claims in the action with such that the original jurisdiction, that they form part of the same case or controversy. I like that shit. Case or controversy. And so essentially 1367A, we basically learned that in order for supplemental jurisdiction to apply, the claim again must lack an independent basis for subject matter jurisdiction and must arise out of the same transaction or occurrence as the claim that has an independent basis for subject matter jurisdiction. So I'm going to say that again. If you don't write anything down for 1367, please write this down. So again, in order for supplemental jurisdiction to apply, the claim must arise out of the same transaction or occurrence. So the claim must arise out of the same transaction or occurrence as the claim that has an independent basis for subject matter jurisdiction, meaning the claim that you got into federal court legitimate. So again, in order for supplemental jurisdiction to apply, the claim, meaning that state law claim that lacks an independent basis to get in, must arise out of the same transaction or occurrence as the claim that has an independent basis for subject matter jurisdiction. So let's talk about that for a while. That makes sense, right? So we're saying, look, if it arises out of the same transaction or occurrence, so what do I mean by transaction? Well, does it arise out of the same breach of contract, the same contract deal, right? Does it arise out of the same automobile accident or plane crash? Like, it just makes sense to have this rule to be more efficient in terms of how you are trying things. But that's what I mean by the same transaction or occurrence. And so as we progress along the semester, the court actually gives you criteria to determine whether or not something qualifies as arising out of the same transaction or occurrence. They give you like a list of things to look for. So we'll talk about that as we move further along. Any questions about 1367A? Okay. Yeah.
Could you repeat the rule for every claim must arise? Please?
Yeah, sure. So if in order for supplemental jurisdiction to apply, the claim must arise out of the same transaction or occurrence as a claim that has an independent basis for subject matter jurisdiction, meaning the claim that you got into federal court on its own. So this is often called the common nucleus test, is what it's been called. And essentially what it says is, as you see up there, grants jurisdiction over all claims asserted in federal civil action if they share a common nucleus of operative fact. Same things, out of the same case and controversy. But if you see in your textbook or in some other materials, the common nucleus test, I just want to make sure you know that that's the same thing as arises out of the same case and controversy. But sometimes they call it that. And again, I will email you this PowerPoint. Even though I'm emailing it, some people still want to write down, so I'm just giving it a minute. Even though it's awkward, when I stand up here and don't say anything. Okay, so 1367C, several parts here. So it basically provides that even if the test from 1367A, that same transaction occurrence test or common nucleus test I just said, even if the test from 1367A is satisfied, federal courts can still decline. They can say, no, we're not going to exercise supplemental jurisdiction if the claim that lacks an independent basis, so if that state law claim, falls into one of those 4 categories. So I kind of have mixed feelings about this. I don't know how I feel about it. Is that fair for them to, like, do we need this 1367C? Because I feel like this. If my claim arises out of the same case and controversy, the same car accident, I don't want some judge being able to tell me, no, you have to go and file that case separately in state court for one of these 4 reasons. I don't like it. The first one is the claim raises a novel or complex issue of state law. So essentially what the federal courts are saying is, hey, this is a unique issue that, it's a state law, and we don't feel as, we interpret federal law. We don't feel qualified in this particular instance for that state law claim, even though it arises out of the same case of controversy. We don't want to misinterpret the law. The second one, the claim substantially predominates over the claim or claims over which the district court has original jurisdiction. So the state law claim is so prevalent, it's really the main basis of the lawsuit anyway. So really this case probably should be tried completely in state court and not in federal court. You're trying to get it in federal court, you think you're going to be at an advantage, when this is really the predominant or the main claim, the main basis of the lawsuit is a state-based claim, which would be better interpreted by a state court judge. The third, the district court has dismissed all claims over which it has original jurisdiction. So sometimes you file a case in federal court based on federal question jurisdiction, and essentially what can happen is the case gets dismissed because someone makes a motion for lack of personal jurisdiction. So the federal claims get dismissed, but then the state law claims, they don't get to just stay in federal court. If the original basis for how you got that case in federal court is dismissed, for whatever reason, then the state law claims have to go back to state court. And that happens in the early part of the lawsuit before, in the pleading stage, so before it even gets to a jury and all that. And then the fourth one I really don't like, because it's too subjective. You can just be trying to screw me over. In exceptional circumstances, there are other compelling reasons for declining jurisdiction. Why? Because your dad is friends with the defendant? I don't like that one. I can accept the first three, because I feel like those are pretty legit. But the fourth one, it's in the interest of justice. What does that mean? That means I get to screw you. And I always tell you the story. I had a cousin in Atlanta who had a DUI. He's calling, oh, I'm going to lose my job. I'm a professional. I'm going to get screwed. I'm going to lose my job finds out. This can't stand. Well, were you drinking and driving, Trevor? I mean, I had a few beers, but no, I wasn't drunk. Oh, okay. Did you pass the sobriety test, Trevor? And so I go down to Atlanta. I do my research. I make some phone calls. They're like, this is the guy you want right here. They ask me what, my lawyer friends, they're like, oh, what court is he going to be in? I say, oh, Fulton County. Oh, you want this guy. Why did I want that guy? Because he plays basketball with the judge. They're on the same basketball team, right? And so, literally, we go. The guy says, give me $10,000. We give him $10,000, and he said, don't worry about it. It's going to all go away. Literally. He said, I'll actually, who's that? Is it me? It's you?
That was a alarm that set like 7 o'clock.
Well, because I know that I said alarms, and it sounded like mine. I'm like, please don't be me. So, we go, we give the guy $10,000, and he says, oh, don't worry, it'll go away. And so Trevor's like, what do you mean? I'm like, I said, it'll go away. I said, don't ask questions. I said, he's fine, thank you, we'll see you in court. He's like, yeah, and so we go meet him in court, right, for our court date, and he's like, listen, it's gonna be real quick. He's like, I just saw the judge and I just played basketball Tuesday night, everything's good. He literally said that to us. We go there, prosecutor attorney's there, she's all like, trying to make a little career for her little self. And, she's like, because he refused to take the blood test or the breathalyzer because he knew it would pass, but they made him walk. But surprisingly, he looked pretty good on camera. And so the judge literally calls up, and I'm sitting here in awe as I watch this process. He's like, well, case Trevor versus State. He's like, I've had a chance to look at all the pleadings, and I've decided it's dismissed. And just drops the file, and he goes, next, case number. And I'm like, what? And I was like, let's go. He was like, thank you. I find the guy who left before I realized what he said. But it shows you that that's why federal judges have lifetime appointments, because people are human. And that state court judge, I'm sorry, but he is obviously susceptible. So we're convinced that he's getting a kickback as well. But isn't that so unfair? So what if you didn't have the $10,000 to pay that guy who's friends with the judge? Like, I think that's so egregious. That's horrible. It's unfair. So because I'm poor, I get screwed and get a DUI, and I can get out of it? And what about when I'm wrongfully accused? So that really jarred me that it was that corrupt. I know the system is corrupt, but to actually see it in action is terrible. So that's why I don't like number 4. Any questions about 1367C? So our cases are going to show you an example of the first and the second one today. All right.
I know what you were doing.
1367B. All right, B as in boy. Or Bravo. All right, so 1367B, which applies only if the original claim is based on diversity jurisdiction. Again, why do they have to complicate stuff? Why can't it just be 1367, no A, B, or C? The bottom line is, if the claim arises out of the same case or controversy, you can add it, right? Why do we have all these little rules? I hate them. So, B only applies if the original jurisdiction, again, is based on diversity jurisdiction. So section 1367B essentially provides a limit to supplemental jurisdiction that in federal actions that are, again, based solely on diversity jurisdiction, the federal court may not exercise supplemental jurisdiction over claims by plaintiffs against parties that were joined by those rules. So it just means that if I'm the plaintiff, there's a defendant that I add into the lawsuit based on one of those rules, which we'll talk about these rules when we get to joinder of claims, we're not allowed to use supplemental jurisdiction. So I had mentioned earlier in pleader and how I can make my business partner come into the lawsuit. So we'll learn that later, but Rule 14 is in pleader. So that's a rule that says I can make my co-partner, someone who might be jointly and severally liable for a claim, I can force them into the lawsuit. So that's the extent that you need to know for now until we get to joinder, and then we'll discuss it again. Just know that 1367B restricts the use of supplemental jurisdiction if the plaintiff has added a party to the lawsuit based on one of those rules. And we will revisit this when we know what those rules are. All right. Another important thing emphasizes that 1367B restricts claims brought by plaintiffs, not by defendants. So it's just the plaintiff. If the plaintiff says, oh, I'm going to add some more state law claim of this co-defendant that just entered the lawsuit. So it's just the plaintiff that has these restrictions for 1367B. And again, when you actually know what rules 14, 19, 20, or 24 are, we'll talk about this again and it'll make more sense. Alrighty. Oh, that's just a proof summary. Okay. That summary helpful there? Just flash by? Oh, sorry. Pretty obvious. I just made it less wordy. So claims by plaintiffs against persons made parties under one of those rules. Made parties just meaning joined by one of those rules. Rule 19. And then claims by persons seeking to intervene as plaintiffs under Rule 24. Intervene, so basically so 14 is I'm forcing somebody in because they might be liable as well. 24 is, hey, the outcome of this lawsuit is going to affect me, so I want to intervene. I want to force myself to be in that lawsuit because this outcome is going to screw over my business. So 24 allows you to intervene. So basically we'll learn later there's all these joinder rules. Is everybody like me today? We'll learn with the joinder rules that there are ways that I can force someone to enter the lawsuit as a defendant, and outside people can say I need to be in that lawsuit because my rights are going to be impacted by the outcome. right? All right, so let's do our case for today. All right, so we've got lending practices. Boy, it's going to be interesting. So let's discuss the facts in this case. So we have the plaintiff, Skanes, started the process of applying for a mortgage with the defendant, AmeriQuest, in 1994. Before the close of the transaction, AmeriQuest ordered from co-defendant Homestead appraisal of the property, which again was going to be hopefully this Skanes' future home. So the mortgage company says we need to get an appraisal of the property. The home was appraised at $163,000, and that's essentially what's going on with the facts. And this is a 2007 case, so it's not super old, but a little more current than usual. So basically, the plaintiff in this case had an issue with the appraisal. So the plaintiff had an argument or issue with the value of their home. And so basically, what the plaintiff argued is that the true value of her home was less than the amount than the amount reflected in the appraisal. And she argued that the reason for the inflation was to increase the loan amount, right? Which she could qualify and thereby increase Quest profit. So when the interest rate was reset, Skanes could not refinance. That's really shady that you're going to appraise my home more than it's worth so you can charge me a higher loan amount. That's like super shady if that's what's going. So let's go through the separate counts in this case in the plaintiff's complaint. And so it tells us essentially what the plaintiff really wants. And so the first one is count 1 of the complaint, right? When I say complaint, we're going to actually draft a complaint at some point in this class, and that's just the pleading, so that's the initial filing that you when you do service the process. You have to list what your issues are, your count 1, count 2, count 3, so that's essentially what's going on. So in count 1 of the complaint, the plaintiff alleged a claim against AmeriQuest under the Federal Truth in Lending Act called TILA, seeking both rescission of the mortgage as well as statutory damages for the dishonesty, violating the statute. For the plaintiff's TILA claim, meaning that statutory claim, the plaintiff states that at the time of her closing, AmeriQuest provided her with improper and misleading disclosures of her right to cancel her mortgage. In counts 2 and 3, she alleges state law fraud claims against all the defendants. So you can see the difference. In count 1, she's alleging a federal claim because it's based on a federal statute, so that's definitely would qualify for subject matter jurisdiction. But counts 2 and 3, she's alleging state law fraud claims, so that's not on its own independent basis be able to get into federal court. In addition, Skanes requests that the court enter judgment declaring what obligation, if any, the plaintiff has towards each defendant after the rescission. So let's talk about what sections of the supplemental jurisdiction statute the court's interpreting and what these sections provide. Okay, so section 1367A, again, as a reminder, provides that any action which federal court already has jurisdiction over some federal claim, the court will also have supplemental jurisdiction over state claims that are so related to claims in the action within such that original jurisdiction that they are considered part of the same case or controversy. And so the court also looks at 1367C, just a reminder that even if it has supplemental jurisdiction over the plaintiff's state law claims, for one of those 4 reasons we discussed earlier, they can deny supplemental jurisdiction. So essentially what the court does in this particular case, let's see if I actually wrote down the right page. Sometimes I do, sometimes I don't. Okay. So basically the court creates a rule for determining whether the federal and state law claims are connected, and I have that up behind me. Essentially what the court says is if there's a loose factual connection that may be sufficient to confer supplemental jurisdiction, so long as those facts are both common and operative, right? That's the little test the court decides to create for 1367A. So they're trying to essentially show you how to determine if the claims arise out of the same case or controversy. So again, they say yes, as long as the facts are both common and operative. So to determine whether the federal and state law claims are connected by common and operative facts, the court routinely compares the facts necessary to provide the elements of the federal claims with those necessary to the success of the state claim. So if you need some of the same pieces of evidence for the federal claim as the state claim, they consider those to be common, meaning the same pieces of evidence, which makes sense. And so the court also said you can also ask whether the state claims can be resolved or dismissed without affecting the federal claims. So again, as you get further along in law, that will make better sense, and I'm sorry, but it's like kind of complicated. But what's important is you're looking at whether the facts are both common and operative. Is there a causal connection between them? So the court goes on to talk about the plaintiff's claim in the context of 1367C, and it basically goes down and says, let's see if any of these 4 reasons apply for us to deny supplemental jurisdiction, and that's 1367C. So they first look at 1367C1, which again, does the claim raise a novel or complex issue of state law? And what the court basically says is that no, okay? They said there's no novel claim based on the Michigan Mortgage Brokers Act, which hasn't so far been applied to appraisers. They say, you might get different precedents on this from Michigan by the time the case is fully dealt with, but we don't see any novel state claim that's so unique that, we don't think that we can litigate it. So that was the first one. They look at 1367C2, which is a claim substantially predominates over the claim or claims over which the district has original jurisdiction. And they say, we don't see a problem here either. They said, with respect to that, they said, because you can't really tell from the face of the plaintiff's complaint, that the state law claims predominate the TILA claims, the federal statute claims. So they said based on the complaint, it's not really clear whether or not the state law claims predominate that TILA statute, so that doesn't apply. And then they look at 1367C3, which again is the district court, whether the district court has dismissed all claims over which they had original jurisdiction, and they say not applicable here either, because the court has not dismissed the federal claim, meaning unclean hands on the part of the plaintiff. That claim has not been dismissed, so you still have that original legitimate basis for subject matter jurisdiction. That claim is still good. And then 4, they're like, okay, well, let's see if there's any exceptional or compelling circumstances that would warrant us not allowing supplemental jurisdiction. And again, they said they don't feel like the defendant has provided any compelling reason not to exercise supplemental jurisdiction. So they went down that whole 4-step criteria. So in terms of the court's holding in this case and rationale, with respect to whether the plaintiff's claims is connected, meaning the federal and state, based on 1367A, basically what the court says is that yes, Skane explicitly connected her federal and state claims, which I think she did as well, such that the court cannot conclude that the state claims can be dismissed or resolved without affecting her TILA claim. They're interconnected, the fraud and what they were trying to do to manipulate her mortgage. They said that the facts underlying her state and federal claims told essentially one story, that Skane did not fully know her right to cancel her mortgage at the outset because that mortgage was overstated or overinflated. She paid too much during the life of her loan. And also because it's overstated, she wasn't able to refinance. I'm kind of messing with Bernardo with this. He saves loading paper. He's dressed very professional. So yeah, so he basically said, that alleging that the TILA violation, Skanes now wishes to avoid her allegedly overstated mortgage. In doing so, again, she expressly links her TILA claim for relief to her state claims, which I agree. Again, she's seeking judgment, voiding her mortgage, and a judgment declaring that if any payment obligation exists into taking into account Skanes' state law challenge and her home appraisal, because they're all interconnected. The court says if they would have dismissed counts 2 and 3, they might be unable to grant, again, the full measure of count 1 because they're so interconnected. And the court, as we know, in this case, grants supplemental jurisdiction to the plaintiff's state law claim in this case. And that's it. So this is an important case. I think it does a great job of showing you how the court applies 1367A, B, and C. Do you have any questions about that case or supplemental jurisdiction? Do you see how her claims were related? The fraud claims go with the appraisal, with the statute, all of that. All right, cool. Our next case, the first Bank Court case, Puerto Rico. So this case is cool because it looks at one of those issues in 1367C about having a novel state law claim. So this case is showing you what that looks like. Do you want to take a 5-minute break or are we moving forward? I know you guys are tired, which is why I'm not calling on you, but I feel so low in here. It's kind of sad. I went to law school, just lost accreditation. You're all screwed. Okay, let's just do 5 minutes.
I'm done.
All right, no late.
Who? Zach? I don't think Zach here.
First thing to do, I don't see it. I feel like everything's going out. Like, we're going to do one more. I think that's fine. We're going to do one more. We're going to have 5 minutes. Alina and I were all dating since we're not having no, I can really fast. I haven't, I don't have to. I looked at it, I can find for him to be seen. I would know before, right? Yeah, you don't know that. Yes, I did. I said this one. Wait, no, sorry. I didn't get I need more coffee.
I didn't even see it. I'm sorry. It still means something.
Okay, so, oh wow. She likes golf, I say, I'm never there. Okay, so we're back. I feel like I got enough energy to finish the flash. Just so you know, because I knew I had to brief today, I was all hyped up. I was like, oh, I'm gonna bring Krispy Kreme and coffee, because I know they're. But when I saw how cold it was this morning, I was making another stop. I was like, it's still not happening. But it was my initial thing. I was like, it's too cold. Yeah, but I wanted to be like the brief thing.
Well, you want us to do till Thursday, so you can maybe like between now and then. Or...
Professor Walker. That's not an inside joke. All right, so let's move on to our last player case so we can ice skate out here. Who watches Naked and Afraid? Doesn't make you a pervert.
I've seen it.
Yeah, so I watched it. It had a special one on yesterday called Tapped Out. And it showed you how, like, all the times people had to tap out and why. And I didn't realize people actually got hurt. Like, for real hurt. Like, this lady, she was boiling water, she fell asleep, the water spilled over, and she had 3rd-degree burns. I'm like, it was like, I was just surprised how people, who would actually be willing to try to do that?
Depends on where. I'm not going nowhere naked.
What I like about it is I admire people seeing how far they can push their mental, it's all mental, to the limits. Yeah, so you would try to be the worst one too?
No, I'll be naked. I have no problem with that. I'm not about to get afraid to lose it.
You gotta do this in the house.
You don't see her coming in your house? Shirt missing?
I didn't think they get paid.
I think it's just for the prestige of saying that you did it.
All right, what's the point? Let's go to Warren, Puerto Rico. Okay, Warren, Puerto Rico. Here we go.
We're still here.
The facts. We got the plaintiff. We got the plaintiff. I don't know how to pronounce her name. Shindre works for Infinite Bank as the general counsel in Puerto Rico, so there we go. In March 2005, the plaintiff received documentation from an external law firm regarding ethical and legal violations by the bank officials in the purchases of mortgage loans from other financial institutions. Basically, the plaintiff conducted an internal investigation and found that there were irregularities, and violations in the code of ethics. It reported the findings to outside counsel for the bank, as well as the bank officials and the board of directors. They're like, there's some dishonest stuff going on. We need to look a little more carefully. After additional events, which officers should be fired, the plaintiff herself was fired from the bank, as a result of this internal investigation, and the bank blamed the plaintiff for some of the events that she had investigated. Wow. So the plaintiff files a case in federal court, and the basis of the plaintiff's complaint for this particular case is that she sued alleging violations of the federal employment law, so Title VII, and additionally stated a number of claims under the laws, state laws of Puerto Rico, for wrongful discharge, violations of the Puerto Rican Constitution, and for defamation and tortious interference with contracts. So she's going for the regular here. So what's interesting in this case is that the court looks at her initial federal claim, again, which was based on Title VII. She wants to add those additional state law or Puerto Rico-based law claims and via supplemental jurisdiction. And surprisingly, the court says no. And so, this surprises me, they said no. Essentially, what they did is they looked at 1367A and said, is there a common nucleus of operative fact? Do these cases arise out of the same case in controversy, and these claims? And the answer is yes. So the court found that 1367A definitely applies. What's interesting, though, is they then went on to see whether or not 1367B applies. And no, because this case originally got into the court based on federal question jurisdiction, remember Title VII, and it was not based upon diversity jurisdiction. So 1367B does not apply. So then the court goes further and says, okay, well, let's look at whether or not 1367C, one of those exceptions applies. And so, excuse me for a second. So essentially in this case, the court looks at 1367A, and the first one is the state law claims raise a complex or novel issue. And surprisingly, the court said, you know what, we think we might have an issue here, and that 1367C1 might be a basis for us to decline supplemental jurisdiction. Essentially what they said is they felt that the state law claims were complex. They said that the main issue that was raised by the defendant in their motion to dismiss is that the plaintiff's prosecution of their claims would run afoul of Canon 21 of the Puerto Rican Code of Professional Ethics. So Canon 21 is a unique code of ethics for the legal profession that's unique to Puerto Rico. And so Canon 21 basically deals with the highly sensitive matters of lawyers' conduct between themselves and clients, and basically that Canon 21 Code of Ethics forbids a client from disclosing client conversations between themselves and the client, meaning forbids lawyers, basically lawyer-client privilege, right? It preserves that. The court in this case, meaning the federal court, says that this Canon 21 Code of Ethics is the province of the Puerto Rican Supreme Court. Canon 21, they said, is very different from our ABA model rules of ethics for attorneys, which was adopted by the court. And they said that Canon 21, meaning the Puerto Rican Code of Ethics, is silent on the issue of what happens when a lawyer brings a claim against a client, and Puerto Rican law has yet to address this issue. So what the federal court is saying is, look, we have a totally different set of ethics, code of ethics for attorneys in the states than the Puerto Rican Canon 21. And not only are there a totally different code of ethics, this particular issue has never been litigated. So there's no precedent for us to look at in Puerto Rican law so that we can interpret the law correctly here in the federal courts. And so because of that, the court said that was one of the reasons they would decline supplemental jurisdiction, because they're like, we don't know this Puerto Rican code of ethics, and more important, it's a new novel issue that's never been addressed. And so for us to try to interpret not only a different code of ethics, but an issue there's no precedent, they felt they should decline supplemental jurisdiction for those reasons. The court also looked at the second section, 1367C2, whether the state law claims predominate the federal claim, meaning that Title VII based claim. And they said, the plaintiff really only has two Title VII claims for discrimination and retaliation, which is true. State claims outnumber Title VII claims, and the scope of the state claims exceed the federal claims, which is true as well. And so remember, she had the two Title VII claims, but for state law claims she had, based on the laws of Puerto Rico, she had wrongful discharge, violations of Puerto Rico Constitution, defamation, tortious interference with contracts. And so the court is saying, so this is an example of how state law claims can predominate the federal claims and how the court examines that. The court said although some of the Puerto Rican claims mimic the federal claims, that the remaining Puerto Rican claims, meaning wrongful discharge, tortious actions infringing on the plaintiff's constitutional rights, and tortious interference with contracts and defamation, are distinct and each has its own elements of proof that is unnecessary to establish the Title VII claim. So I had mentioned earlier the courts, when they're trying to determine whether not only state laws claims predominate the federal claims, but they're also trying to see if they arise out of the same case or controversy. What they'll do is see what elements of this claim do you need to prove, and are they the same evidentiary basis for both claims? Like for instance, torts, let's see, I'll do I guess assault. They have to be imminent apprehension of harmful or offensive contact. So those are elements for an assault claim. So they'll look at if those elements are the same claims that you need for intentional infliction of emotional distress. Well, they're not. And so that's what they're saying, that when they're looking at what elements of proof are needed for each of those state law claims, they're seeing if the same elements of proof that are needed for the state law claims are needed for those two Title VII claims, and they're saying the answer is no. So this case is an example of how a court can decline supplemental jurisdiction because one or more of those areas of 1367C are applicable. So you can see how it is in the interest of fairness for the court not to try to interpret not only a different area of law, but one that's in an area where there's no precedent as well. And you can see how this, like in this case, the state claims, predominate the federal claims so much, whereas obviously the case should just be in state court. They're just trying to get it in federal court based on those two little claims because they think they're going to have a better outcome. So any questions about the First Bank Court case? And really the only point of you reading is to see how that 1367C is applied in a factual setting. So can someone tell me, I said I wouldn't call the purpose of supplemental jurisdiction. What do we use it for? Supplemental jurisdiction. You really raise your hand.
These would catch claims that independently would not stand in a federal jurisdiction.
Excellent. And the claims are typically opposite the state law claims. Excellent. All right. So removal, I'm going to just explain what that is, and then we'll do the Caterpillar case tomorrow. I'll adjust the readings. So that's the end of supplemental jurisdiction. If you have questions, ask. If not, I'm going to move on to removal. Okay. So removal. So removal refers to the ability of the defendant, I want to stress the defendant, not the plaintiff, to move or shift a case that the plaintiff has originally filed in federal court. Only civil actions in which the federal district court has original jurisdiction may be moved. So again, removal refers to the ability of the defendant to move or shift a case that the plaintiff has originally filed in state court to a federal court. The plaintiff files a case in state court. The defendant says, oh no, I need this case to be in federal court. I'm going to totally get screwed here because this is against a local business here. I would say it wrong. Is it Heine Brothers? Coffee, and the state court judges are going to be lenient, trying to show that they're pro, removal first, and I need to be in federal court. I'm going to get totally screwed. So I need this case transferred. Even though the plaintiff filed the original case in state court, I need it in federal court. So the right to remove a case from state court to federal court is, again, the defendant's right, not the plaintiff's right. The statutory basis for removal is 1441. That's the number. If you Google Civil Procedure Rule 1441, removal will come up. And essentially, 1441A provides that any civil action brought in state court may be removed by the defendant or defendants. Important thing to emphasize, if there's more than one defendant, all defendants have to agree to removal, meaning to move the court to federal court. If one out of the three defendants says, no, I don't want the case moved, it can't happen. So that you need consensus of all the defendants for removal. I'm going to wait on that one. Takes a little bit more explanation. So that's all you know now for removal. And you can only remove from state court to federal court. You cannot do the inverse. So you can only go up, can't go down. You can only move from state court to federal court. And remember, with venue, you're transferring within the same court system. With removal, you're allowed to go from one court system to another, from the state court system to a federal court system. All right, I will see you Tuesday.
So sorry.